final third part of the Q&A, questions you asked in comment section about divorce. What are my rights if I think my spouse is hiding assets? There are so many ways to hide assets. For example, if the asset is hidden in cryptocurrency, your rights are to subpoena the bank or ask the spouse to provide all the bank accounts for all these years and look where the money went. If it went to Coinbase, I would subpoena Coinbase account. If it's Binance, it's very complicated. It gets very complicated, but the money needed to go from somewhere to that cryptocurrency account. So it usually will come from either PayPal or investment account or bank account. So that way you can see how much went out and then potentially subpoena that platform and depose the spouse to ask what did that spouse buy. I could imagine that spouse would say, oh yeah, I bought cryptocurrency and then I put it on external wallet and then I lost it and now I don't have anything.
Hard drive is buried in landfill.
It gets very complicated, but regardless, that half of the money would need to go to you because that spouse bought something. They couldn't credibly, convince the judge that they truly lost everything, but at least the half of the money that went out from community property account needs to be reimbursed. And then, of course, if subpoena comes out that this money still is in that account, then it will be divided, whatever is left. So if they bought some cryptocurrency that went down in value, then community is not going to get anything. If it went up in value, then community is going to get half. The second way to hide assets is cash. This is more difficult because it's hard to trace. There is if someone is paying the spouse in cash, and let's say they have a dental office, and someone comes to the office and pays $7,000 for their retainers, for their Invisalign retainers. How can you prove it? You can look at client ledgers, request a ledger from the software, and see if the payment was entered and how it was paid. Sometimes it will not be shown. Sometimes you will see it doesn't match. But a forensic accountant who specializes in these type of tracings with this type of ledgers will know. Another way to add, the trickiest way I have seen people hide money is they open different LLCs in different names and own assets in these LLCs. But again, it has to begin somewhere. The beginning is always someone has a bank account. So if they open an LLC and there was nothing in the bank account, they open an LLC in the bank account and that LLC is making money independently because that spouse puts effort, then I would depose the spouse, subpoena the LLC. It becomes more difficult if those corporations are outside of America, Canada, everywhere. Then I would hire an attorney outside of America to subpoena these LLC. But you have to do a really good research, hire a private investigator, see what names they use because they cannot hide everything. So someone is going to be from their friend circle, because if you're married, okay, his partner name is this, then he has this LLC. You can subpoena the partner's LLC to see if there's any connection, if the money is flowing anywhere. And what I do when people hide assets, I always hire a private investigator and forensic accountant to guide through the intricacies, because some people change their social security numbers, they change the letters of their name so they can open a bank account under alias. It becomes really complicated, but you have to be your best detective. You have to know your spouse. You have to know the names of the friends, business partners. And if you don't, then it can be subpoenaed. It can be discovered. It's all discoverable eventually. Now, the cost factor. It becomes difficult when a spouse who wants to know how much the other spouse is hiding is spending so much money in discovery to then find out that the other spouse was not hiding as much or at all. That is a question to discuss with the lawyer at the beginning, so there is no surprise afterwards. Sometimes I say, okay, how much do you want to spend? And there are different options what we can do and how much it will cost, how much you're willing to spend. I have a case that I'm not in, but from a friend of a friend. She spent $300,000 to discover nothing, and at the end, she pays him spousal support. It just doesn't make any sense. But I can see the urge to know the truth, but outweigh the benefit and cost in every case. Cost analysis, benefit analysis, and also internal price of peace, right? Do I really, really need to know? Or I want to step outside of this marriage, close this chapter, and build my own empire versus chasing to find something, we don't know what. Next question. How do I modify child custody or support orders after divorce? First of all, you would need to file a request for order called RFO, a form FL 300, and most people forget, even lawyers, you have to serve the other spouse in person. Everything post-divorce has to be served in person. And then you have to follow the rules. You have to attach your income and expense declaration. You have to provide your 2 years of sealed tax returns, your RFO, your FL 157, FL 158, FL 319. If you ask for attorney's fees, attorney fee declaration, because if you're modifying child support, then you're also entitled to attorney's fees. How can you modify? Well, if something changed, if the other spouse situation changed, if they make more money, then you can modify. If your situation changed, you make less money, then you would be, if you don't know, then you would need to file a request for order to reopen a discovery because the other spouse doesn't voluntarily provide their income and expense information, so that you need to reopen the discovery. I prefer to create judgments if there's child support that it's automatic open discovery for the purposes of child support and spousal support modification. Usually it's for child support because spousal support has a termination date. But child support, I would say that each party has to exchange either every 3 months their pay stubs or once a year tax returns, whatever the case calls for, so that it's clear that if they don't do it, I can go and enforce that order instead of reopening the discovery. Next question. What should I do to prepare for divorce mediation? I touched upon it in my other video, my video number 2 out of 3. In order to prepare for divorce mediation, I would strongly suggest to not be your own accountant. Hire an accountant who is specialized in creating assets and debt split, who understands how spousal support and child support is calculated, who understands how to buy out from certain things such as retirement account potentially or spousal support, home, someone who can do the paper. And they will tell you they will need certain things. And usually these things include all bank accounts, appraisals for the home, for business, for anything that involves money that needs to be divided. So how can you prepare? Well, make sure if you know you're getting divorced, try to get all the financial information from your spouse and understand the whole picture before you have to pay money on attorney to do the discovery. So the more prepared you are financially, the more paperwork you have, bank accounts for the last 7 years, 10 years, whatever you can, because the spouse who is claiming that the asset should be separate property, meaning if I claim I had $100,000 before marriage, it should be mine, I have the burden of proof to show it. If I'm claiming that the debt this other spouse incurred should not be community, I have to prove it. Wherever it's not 50-50, I have to prove it, whoever is claiming it. And final question. Question number 12. How can I protect my business in a divorce? This is a tricky question. So, business created during marriage is community business. So let's say we have a restaurant business. How to protect it? There is no way to protect it because you gotta evaluate the business. Well, maybe you can choose a reputable evaluator who will have their understanding of the type of business you are in to evaluate it at a reasonable price. But the court will not allow you to sell the business, meaning you're already protected by the law where the other spouse will not force you to sell the business. So the court will maintain the status quo, but then the other spouse can be bought out in installment payments in order to satisfy their portion of the business. So if the business was opened before marriage, of course, the spouse doesn't get the full amount of value and the buyout value of the business. And there are different ways to evaluate the business. So one way to evaluate it is to look how much is in all bank accounts and tangible assets. And then another way is, in addition to that, goodwill. For example, if the business has dental practice, it has a specific floor, specific view, it has value. And the third way, either spouse can say, well, I have a buyer who's willing to pay X amount, so this business is no more, or it is actually more, depend which side you represent or on which side you are. That business, the buyer determines the value, or the market determines the value, or the broker, who could be a witness, an expert witness in this case, to say, okay, this business, according to my market research, is valued at X. So how to protect it? Create a prenup. That's the only way. If you want your business to be protected, make it clear from the beginning that this business is 100% separate property. If there is no prenup, then you got to work with the tools I just described. So if you have any questions, link them down below. You need to schedule a consultation. Check out the description box for the link. Check out my new project called divorceacademy.org, where I have case-specific videos involving other specialists, interviews, and these videos are much longer than 30-minute long, and they're $300 each. So if you want to dive deeper to these topics, check it out, and I will see you soon. Bye.